I've had the opportunity on 5 occasions to represent the city in front of the Central Coast Regional Water Quality Control Board. Most recently, Mayor Tate and our City Attorney Janet Kern joined me, and they got to see what I've been telling you all along. This is a very complex, contentious, even adversarial process. And we went to the Central Coast Regional Board 10 days ago because they were considering what's called a comprehensive cleanup and abatement order, which would tell the Olin Corporation, which had previously been identified as the responsible party for contaminating our groundwater, it would tell the Olin Corporation what to do and when to do it and how their efforts would be measured. From Morgan Hill's perspective, we had considerable concern about the draft CAO that had been put forward for public comment, because it said that notwithstanding the fact that 38,000 people in Morgan Hill rely on groundwater that has been contaminated by Olin, it wasn't contaminated enough, in the regional board's view, to require any active remediation by Olin. So the CAO, the Cleanup and Abatement Order, as drafted, would have allowed the Olin Corporation to adopt a strategy which is, I thought was at first a euphemism, but apparently is a legal term, or a technical term, to monitored attenuation. To monitor something is to look at it and report it from time to time. And attenuation means do nothing. Let nature take its course. So the strategy that the CAO would have allowed in the area that affects us and our drinking water would have simply required the Olin Corporation to peek in every once in a while and see whether nature is leading to the reduction of the contamination that is impacting our supply. So we were concerned about that. The CAO did direct the Olin Corporation to do active remediation efforts in, let's call it, the hottest zones. And those were further south of our town. And the CAO was later amended even to require that the next hottest level also receive some remediation. But still no attention to that portion of the basin that's been contaminated by Olin, from which we draw our drinking water. Secondly, we pointed out to the regional board that our Tennant Avenue well, which, as you know, is south of the Olin site, is a well that is operating, and when it operates on ion exchange, and so the city and its ratepayers are removing perchlorate from the groundwater basin. And we thought, here is a perfect example of an opportunity for Olin to actively remediate the basin, take their perchlorate out of our water, and use the Tennant Avenue well. So we were seeking an order from the board to have Olin use our Tennant Avenue well for remediation. And then third, we asked the board to issue a replacement water order. Now this is of a completely different nature than a cleanup order. A replacement water is whenever a user of the groundwater finds themselves having to use contaminated water above the drinking water standard, which is greater than 6 parts per billion, then the polluter is required to provide replacement water. Now the issue, the contentiousness, the adversarial nature of this was Olin's contention that they had already replaced our Tennant Avenue well when they did pay for the development of the San Pedro well. And we fully acknowledge that they did indeed paid over $700,000 toward the development of that well, which was much needed for our system. But our family continued to grow, and our water needs continued to grow, and we needed to find other sources. And as you know, more than most of the people in our community, we have tried on 3 unsuccessful occasions to find alternative sources. And it became necessary during the peak hours of our summer demand to use the Tennant Avenue well, even though its raw water was contaminated to a degree of 6 or more parts per billion. And we would pay for ion exchange so that we could assure our residents that we were taking that perchlorate out. We were asking the board to order Olin to replace the water that we were using from the Tennant Avenue well. We struck out on all 3 requests. We were joined by representatives of the county, representatives of the Water District, Representative Assemblymember Laird. State Senator Maldonado wrote a very helpful letter, but frankly, his letter was not allowed into the record because the record was closed a few days prior to the hearing. It was a very unusual proceeding. We lost on all 3 points, but at the end of the meeting, as I said, we had some sympathy from board members. Board members asked whether there wasn't anything the lawyers would let them do. And it was suggested that Morgan Hill be invited to submit a legal brief on the question, can the regional board legally order Olin to replace our Tennant Avenue water? I'm not sure that a briefing schedule has finally been determined on that, but within 30 days or so we'll be submitting briefs and in hopefulness that the board will get to reconsider that issue. But because of the potential delays of reconsideration, the council has indicated its intent to appeal the decision of the regional board to issue this CAO without the 3 things we had asked for.